Hello, everyone. So, welcome to this episode for the law series. We're going to be tackling Unit 2, Section B, so tort law, but just the offences of tort law, remedies, of course, and evaluations. I'll do in a separate video. I'll do all of the evaluations in a separate video. So negligence. To prove negligence, we must prove that D owed C a duty of care and that such was breached because they fell below the standard of care. Such a breach must have then caused the damage sustained to C. Determining whether there is a duty of care owed originates from the neighbour principle established by Lord Atkins in Donoghue v Stevenson, stating that a duty of care is owed to those who are so directly and closely affected by my actions that I ought reasonably to have them in my contemplation. This was made comprehensive in Headley, Byrne v Heller, and refined in Capara v Dickman. So proving the onus of a duty of care requires the three-stage test derived from Capara v Dickman to be applied, except if such a duty is commonly pre-established, such as one employed by the Road Traffic Act. This is seen in Robinson v CCWP, Chief Constable, West Yorkshire Police Department. The three-stage test from Capara v Dickman first is whether the damage is reasonably foreseeable. This is in Kent v Griffiths. Next, the relationship between the breach and damage must be close enough in proximity, so space and time, or relationship, that's in Borehill v Young. However, this has been expanded to the immediate aftermath of events seen in McLaughlin v O'Brien. The third test to determine whether there is a duty owed is whether employing such a duty would be fair, just and reasonable. Hill v Chief Constable of West Yorkshire Police Department tells us that courts are reluctant to impose a duty on public services unless if they make it worse. That's Capital and County v Hampshire Council. The next element of negligence is breach. They must have fallen below the standards of a quote-unquote reasonable man. That's seen in Blythe v Birmingham Waterworks, which is the standard of an ordinary man performing the task reasonably competently. This means that learners are judged as professionals, so Weston v Nettleship. Professionals are judged at the standard of a competent professional performing their ordinary duties, so that's Bolam v Friar Hospital Management Committee. Patients must be fully told of risks of procedure. However, extremely remote risks do not need to be elaborated upon. That's Montgomery versus Lanarkshire. Children are judged at the standard of an ordinary competent child of the same age. That's Mullins v Richard. The standard of care may be raised or it may be lowered depending on various risk factors, whether it is a high risk, so Haley v LED, or a low risk, Bolton v Stone, characteristics of the claimant, Paris v Stepney, whether precautions have been taken considering the cost of taking precautions versus the level of risk, so Latimer v AAC. So essentially what it's saying here is, for example, if you're in a road traffic accident and the main damage has been caused because your passenger hasn't worn a seatbelt, you as the driver, you're liable because the cost of telling them to put their seatbelt on versus the level of risk, it's so imbalanced. It costs nothing to put your seatbelt on. Also, I'll fix that spelling mistake. Whether the risks were in fact known at the time, so that's Roe v Minister of Health, and whether the defendant was reacting to an emergency, that's Watts v Hertfordshire. There must be a proven causal relationship established between the breach of duty and the damage sustained. This is done by establishing factual causation by using the but-for test. So this is an R v White this time. It's Barnett v Chelsea and Kensington HMC. But for the Defendants Act, would the claimant have sustained damage anyway? Legal causation seen in Lamb v Camden LBC. So you should never use R v White or R v Kimsey in tort acts in tort case law, because those are criminal cases, so they can't be applied here. The only kind of hybrid offences where tortious case law might be used is in gross negligence manslaughter. Hold on. Here we go. So we must prove that damage is not too reliable. We must prove that damage is not too remote, the wagon mount, as the defendant cannot be liable if damage is not foreseeable. The damage foreseen must be the type of damage sustained rather than the damage itself. That's Hughes v Lord Advocate. Defenses to negligence include contributory negligence and consent. You should start with the strongest defense first, so you start with consent as it is a full defense, contributory negligence is a partial defense, although it has shown the capabilities to warrant being kind of a full-ish defense. There are three elements to discuss: knowledge of risk, free choice, and acceptance of the risk. Knowledge of risk, seen in Sturmer v. Lawson, must equate to a full understanding of the specific nature of the actual risk. Partial or substantial knowledge of the nature of the actual risk is not enough. The defendant must have a choice, Smith v. Baker. A duty as part of their job does not invalidate the defense of consent, that's Haynes v. Harwood. As such, the law does not penalise those who act in emergency to prevent harm from others. Acceptance of the risk does not require a detailed explanation of remote side effects, Sideways v. Governors of Bethlehem Royal and Manstey Hospital. ICI Limited v. Shatwell states that if the claimant acts against an employer's orders or statutory rules, then the valenti defense is likely to succeed. So when you're tackling this in your essays and whatnot, if you can apply this case and you can say it on a balance of probabilities, it's more likely that the valenti defense will be able to be applied to this case, considering that the standard of proof when dealing with tortious offences is much lower than that of criminal offences. So beyond reasonable doubt, if you're able to equate it to a percentage, beyond reasonable doubt would be around a 99% chance plus, right? However, when you're dealing with tort law, it's on a balance of probabilities. So this is just a 49 to 51% chance at the bare minimum. So then if you can apply this case, then it's likely to shift the balance to above 49%. And once you have above 50%, that's when your defense is likely to succeed, or conversely, your tortious offense, your prosecution is likely to succeed. So, Waldridge v. Sumner, acceptance of the risk requires the acceptance of the full extent of the risk. Case specifically, for the valenti defense to succeed, it would require the claimant to have consented to the lack of reasonable care that would have produced the risk. Contributory negligence is a partial defense and results in a remedy that is proportional to the level of contribution to the claimant's own damage. This revolves around the concept that the claimant contributed to their own damage. This judge will calculate the damages awarded and will deduct a percentage based on the ruling. So the Law Reform Contributory Negligence Act 1945. Sires v. Harlow Urban District Council reduced damages by 25% due to a foolish means to escape. Jayers v. IMI Limited demonstrates damages can be reduced by 100%. Not wearing a helmet can reduce damages by 15%, that's O'Connell v. Jackson, and seatbelt 20% in Froome v. Butcher. Accepting a lift from an intoxicated person is seen to reduce damages awarded by 33%, that's Stinton v. Stinton. Committing a crime, 66% seen in Revel v. Newbury. Vicarious liability rides on the principle that an employer or a third party is able to be held tortiously liable for the acts or omissions of their employee. Vicarious liability is established whether the person alleged to commit the act was an employee and whether the tort was committed during the course of employment. We must establish whether he is an employee. So in previous years, tests such as the control test in Yerwins v. Noakes and the organisation test in Stevenson, Jordan and Harrison v. McDonald and Evans has been used. However, ready-mixed concrete has allowed for a three-stage test derived from McKenna Justice to be used. First, there must be proof that the employee provides a skill or work for a wage. Secondly, the employee must expressly or impliedly accept that the work will be subject to the control of the employer. Thirdly, all other considerations in the contract must be consistent with a contract of employment rather than any other relationship. So when you're evaluating this one and kind of weighing up your case facts to decide for this part of the three-stage test, you should look for features such as uniforms, working hours, use of company equipment, things that separate them from being an independent contractor and an actual employee. So if they're given a specific, like it's said there, but if you're given a specific wage, given specific working hours, you're told to act a certain way. However, be careful. I believe a code of conduct isn't necessarily an indicator of employment. As if, let's say you are employing not necessarily employing, but let's say you are hiring an independent contractor that would be classed as an independent contractor under tort law, you're still likely, for practical reasons, to give them a code of conduct. Because then if you were to fire them, for example, or to release them early, this is hypothetical, so it may be slightly inaccurate, but if they're not given a code of conduct and they break that code of conduct and you penalize them for that, or you fire them because of that, then they might bring a claim against you because they were given a code of conduct anyway. But this is all conjecture. This is not anything that I know for sure, but it's just something that I would estimate based on just intuition, I suppose. So be wary of via systems v thermal transfer. More than one employer can be vicariously liable. So Lister v Hesley Hall, a relationship akin to employment, and Catholic Child Welfare Society, liability for an employee of another organisation, has driven development in this area in recent years. Lister v Hesley Hall asked a question: is the employee/employer relationship akin to employment? Is the alleged tort closely connected to employment? Catholic v Child Welfare Society argued in favour of the claimant. The nature of the teacher's relationship was close to that of an employer's based on the ability of the institute to dictate where they are taught and how bound they were to the rules of the organisation. So this is more loosely said than giving them just a code of conduct. So excuse my voice, I'm ill. So if you are giving them a strict code of conduct, it can be an indicator that they are an employee for sure, but at the same time, an independent contractor still is likely to be given a code of conduct, especially I would assume if it's long-term work. So if it's work over the span of 6 months that requires multiple projects, things such as deadlines, etc., they might be given, or a code of conduct might be given. So but you can use Catholic v Child Welfare Society to argue if somebody is strictly bound to the code of conduct, then it may be akin to employment. So Mohammed v Morrison Supermarket caused a two-stage test by Lord Tolson to be formulated. What functions or field of activities have been entrusted by the employer to the employee? What was the nature of his job? Was there sufficient connections between positions in which he was employed and his wrongful conduct to make it right for the employer to be held liable under the principle of social justice? It has been established that you do not need a contract of employment to be considered an employee. Remember this, that's Cox v Ministry of Justice. A relationship other than one of employment is in principle capable of giving rise to vicarious liability, where harm is wrongfully done by an individual who carries on activities as an integral part of business activities. So if you look at what's bolded here, these are the most important parts of the quote. So integral part of business activities, that's the distinguishing factor between an independent contractor and employee. Because again, a company might just hire an independent contractor just for extra help, but not because they will be an integral part of the company. Otherwise, it's almost counterintuitive. Also remember, I believe, I'll say in the comments if this is incorrect. So take this as you will, but I believe Mohammed v Morrison Supermarket was a criminal offence as well. So if you have a case where a employee has committed a criminal act against somebody else, the claimant, then you can use this case. So the second element requires us to determine that the torts committed by E were done so during the course of the employment and is decided by the courts. Recent judgments appear to be weighted in favour of claimants who have been injured by the employee. Acting against orders may absolve the employer, but this is not a certainty. Limpers v London General states that employers can be held liable where the employee has gone against company orders. So this is seen as well in Rose v Plenty. This states that an employer is vicariously liable if they are benefiting from the work of children. So they were explicitly stated, and they were explicitly said in the Code of Conduct not to use children as work. However, they used work anyway. They used children for the work anyway. Despite this, the employer was still held liable. However, Beard v London General Omnibus states that an employer will not be liable if the employee is acting outside of the course of employment, so on a frolic of his own, for instance. So in Hilton v Burton Limited. Matters v. Pollock, clubs can be found vicariously liable if they order bouncer to keep order, which includes violence. NV Chief Constable of Mersey Police Station states that the presence of uniform itself on a police officer does not guarantee vicarious liability. So you can use this like widely, however, just for contextual purposes, it is on a police officer. So take that as you will and apply it appropriately. Mohammed v. Morrison's provided justice for an attack by an employee, so a criminal act. Century Insurance states that employers can be held vicariously liable for negligent acts of employees. However, acts or omissions outside of the area or time of their work cannot be held liable. That's Hilton v. Thomas Burton Limited. So, in this case, it was described that the employee was acting on a frolic of his own. Smith v. Stages was the same circumstance. However, they were getting paid throughout their journey. The employer was able to be found vicariously liable. So, the Occupiers Liability Act 1957. So, occupiers liability concerns the responsibility of an occupier to ensure the safety of people whilst they are on their property. This was created in the 57 Act and extended to trespassers in the 84 Act. So, when you're tackling this in your essay, first you need to establish the fundamental aspects of an OL claim. The occupier's control over the premises at which the injury took place, and that D was a visitor, lawful or not, will depend on which act you use. So if they're a lawful visitor / child, then you use 57. If they are a trespasser, then you use 84. The definition of occupier must be addressed, as there is no statutory definition. This is because there may be occupiers of premises who may be, but do not have to be, the owner or tenant of the premises. This is usually the person who has control over the state that the property is in, but this can be more than one person, so that's Wheat v. Laken. Harris v. Birkenhead states that an occupier of premises may not have even taken control yet. A good indicator may be whoever's insurance policy covers the premises. However, Bailey v. Arms states that it may be such that there is no sufficient control to warrant anybody as the occupier. This definition of premises must be addressed too, for the same reason. However, Section 1, Subsection 3, Subsection A of the Occupiers Liability Act 1957 states that a premises is any fixed or movable structure, including any vessel, vehicle, or aircraft. Case law has held that lifts and ladders can also be included in the classification of premises as well. Section 2 of the Occupiers Liability Act of 1957 requires adult visitors to be owed a duty of care by occupiers. These can be invitees, people invited, and those who have expressed permission to be on the premises. Licensees, people who have expressed or implied permission to be on the land for a particular period and or purpose. This might be contractual permission, so an entry ticket for an event, for instance, let's say you're going clubbing or a concert. So also, if you have a statutory right of entry, so meter readers, police officers exercising a warrant as well have a statutory right of entry into premises. Section 2, Subsection 2 of the Occupiers Liability Act 1957 states that adult visitors are owed a common duty of care to take such care as in all of the circumstances is reasonable to see that the visitor will be reasonably safe in using the premises for the purpose of which he is invited to be there. There is an absence of need to go above and beyond, so that's Laverton v. Kia Pasha, and only reasonable steps to guard against a real source of danger are required. That's Dean and Chapter of Rochester v. DeBell. So, an occupier owes the standard common duty of care owed to adults as to children, but there is an additional special duty under Section 2, Subsection 3 of the Occupiers Liability Act 1957. This states that the occupier must be prepared for children to be less careful than adults. Subsequently, the premises must be reasonably safe for a child of that age. This is measured objectively according to the age of the child. The occupier must guard against any allurement or attraction which places any child visitor at risk of harm, seen in Glasgow Corporation v. Taylor. Young children cause the courts to be reluctant to prosecute the occupier, as they must be and should be under the supervision of their parent/guardian, that's Phipps v. Rochester. Despite this, there is no age limit to define young children. Access the age of the child and two extremes of the child visitor spectrum. So that GC v. Taylor and Phipps. That's more of an instruction of what to do in your essays. So occupiers owe a common duty to those carrying out a trade. However, Section 2, subsection 3, subsection B of the Occupiers Liability Act 1957 states that an occupier can expect that tradespeople will appreciate and guard against any special risks ordinarily incident to it, so far as the occupier leaves him free to do so. As a result, occupiers are not necessarily liable where a tradesperson/people have failed to guard against special dangers that they should be aware of. That's Rolls v. Nathan. So independent contractors may have the responsibilities of an employer passed on to them. Section 2, subsection 4 of the Occupiers Liability Act 1957 states that if the visitor to land is injured by a workman's negligent work, the occupier may have a defence and may be able to pass the claim to the workman. There are 3 requirements needed to argue this, however. Firstly, it must be reasonable for the occupier to have given the work to the independent contractor. That's Hazeldean v. Dorr and Son. The more complicated and specialist the work, the more likely it is for the occupier to have given the work to a specialist. Secondly, the contractor hired must be competent enough to carry out the task. So that's Bottomley v. Todd Morden Cricket Club. The occupier should check references/recommendations or check with the trades association, and they should check that the contractor is completely and is properly insured. Lastly, a check with that occupier that the work has been properly done. So Woodward v. Mayor of Hastings must have been executed. Where the work is very complicated, however, the occupier is required to employ an expert to verify such as an electrician, architect or surveyor. So trespassers, this is the 84 Act now. Section 1, subsection A of the Occupiers Liability Act 1984 states that a duty applies in respect of people other than lawful visitors. 4. Injury on the premises by reason of any danger due to the state of the premises or things done or omitted to be done on them. The 84 Act provides compensation for personal injury only, however. Property damage is not covered. This provides less protection than that given to lawful visitors. So Section 1, subsection 3 of the Occupiers Liability Act 1984 states that the occupier will only owe a duty if A. He is aware of the danger or has reasonable grounds to believe it exists. B. He knows or has reasonable grounds to believe that the other is in the vicinity of the danger concerned, or that he must come into the vicinity of the danger. In either case, whether or not the other has lawful authority for being in the vicinity or not. C. The risk is one against which, in all of the circumstances of the case, he may be expected to offer the other some protection. Section 1, subsection 4 states that the occupier must take such care as is reasonable in the circumstance to see that the trespasser is not injured by the reason of the danger. The danger is the object that injures the trespasser, or part of land on which the trespasser is injured. The standard of care is objective. So this is away from the claimant's point of view, the defendant's point of view, for instance. What is required, however, depends on the circumstance of each case. Relevant factors include the nature of the premises, the degree of risk, the practicality of taking precautions, and the age of the trespassers. Case rulings are available to consider when determining a standard of care for trespassers. Ratcliffe v. McConnell states that an occupier is not liable if an adult is injured by an obvious danger, whilst Tomlinson v. Congleton, BC states that an occupier does not have to spend a lot of money protecting trespassers from obvious dangers. Ryan v. Asbury Water Park states that there is no liability if the occupier was unaware of the danger or had no reason to suspect the existence of such. So this offers protection to the defendant in this case, actually, which may align more in favour with public opinion. Higgs v. Foster ruled there to be no liability if there was no reason to suspect the presence of trespassers. Seasonal factors, such as the time of day or time of year, Donoghue v. Folkestone Properties, can be considered to excuse the occupier. Statutory rules apply to children as adults, and the approach of judges is the same. So that's Keown or Kewan or Cone v. Coventry NHS Trust, and Baldacchino v. West Wittering. So, private nuisance now. A private nuisance claim requires there to be an unlawful interference with a person's use or enjoyment of land coming from neighbouring land. Determine whether the interference was unlawful, the type of interference, and the reasonableness of the use of land. The first element is unlawful use of land. Unlawful more refers to as unreasonable, since we're talking about tort here and not criminal. Is it a reasonable consequence for C to suffer because of the interference? So determine the type of interference. Hunter v. Canary Wharf states that nuisances should be categorized into one of the two categories. Encroachment. So these actions directly affect the property of C. Physical damage to property or interference with the enjoyment of land. Interference with the enjoyment of land. Thompson, Schwab v. Kostaki, courts are prepared to protect feelings of emotional distress. So it says two categories because interference with enjoyment of land falls into physical damage. So Miller v. Jackson states that a nuisance can fit into more than one category. A right to light / a view, Bland v. Mosley, does not amount to a nuisance. So consider the 5 factors of reasonableness. Locality, so character of the neighbourhood, Sturgis v. Bridgman. To be actionable, the interference must show to be continuous and at unreasonable time periods. Crown River Cruises v. Kimbolton Fireworks showed that it could be a brief nuisance if it is the kind and at times that make it unreasonable. Sensitivity of the claimant. Network Rail Infrastructure v. Morris. This should be seen more as a reasonable foreseeability of the nuisance recently. Deliberately harmful. Malicious acts will normally be considered unreasonable behaviour and therefore a nuisance. Hollywood Silver Fox Farm v. Emmett. Miller v. Jackson. A benefit to the community may result in the courts considering the act to be reasonable. So defences. Prescription. Sturgis v. Bridgman. Statutory authority. Allen v. Gulf Oil Refining. Consent if there are active steps taken by the claimant encouraging the creation of the nuisance. Moving to the nuisance, Miller v. Jackson does not apply. To prove that C has a claim for Rylance v. Fletcher, we must prove that D brought onto land something that is likely to cause mischief if it escapes, that it amounts to a non-natural use of said land, and which does escape or causes reasonably foreseeable damage to the adjoining property. Natural presenting objects and items show no liability, seen in Giles v. Walker. Elision v. Ministry of Justice supports this. There was no liability for something that naturally accumulates on land. Fire could be a claim if it is caused by an unnatural thing brought onto land. So Standard v. Gore, LMS v. Styrene. So be careful here. It's not the fire itself which brings about the Rylance v. Fletcher claim, but it is the thing that started the fire. If the thing that started the fire warrants a non-natural use of land, then Rylance v. Fletcher can be used. So Lord Moulton in Rickers v. Lothian states that it must be some special use bringing it with an increased danger to others. For example, in Cambridge Water Co. via Eastern Counties Leather, the storage of chemicals at a factory was non-natural. Leaving a car in a garage with petrol in a tank was non-natural in Musgrove v. Penderless in 1919, but it would not be today. So consider the state of societal progression, and then consider such when tackling with some case laws. So the final element must prove that the thing which was stored escaped and caused foreseeable damage. So Red v. Lyons, an escape from a place where the defendant has occupation or control over land to a place which is outside his occupation or control. So if I bring, let's say, acid onto a land and it leaks from my back garden into my neighbour's back garden and causes damage, then that's a Rylance v. Fletcher claim because it's brought from a place that I have control on, so my back garden to my neighbour's back garden, which is outside my occupation or control, as it doesn't belong to me and I can't control it because it's my neighbour's. So Transco v. Stockport, Metropolitan BC states that damage should be to an adjoining property. Cambridge Waterco v. Eastern Counties Leather states that damage must be reasonably foreseeable. So the defences to Rylance v. Fletcher, which include consent, statutory authority, contributory negligence, act of a stranger in Perry v. Kendricks, act of God, which is in Nichols v. Marsland. So that's just natural disasters. I don't know why it has such a dramatic name. So remedies. Damages. Compensatory damages, The tort claims can result in the court awarding a successful claimant compensation for the injuries they have suffered from or damage to their property. This is referred to as damages. The aim of the reward or the award of damages is to place the claimant in the same position as if the tort had not been committed. Calculations of how the award will be handled is decided between whether it is a special damage or general damages. So special damages refer to a quantifiable financial loss up to the date of the trial from the date of the tort. These are assessed separately from other rewards as they tackle exact claimed amounts that are known at the time of the trial. For example, a loss of earnings. To calculate the required damages from a loss of earnings from the date of the tort to the trial, the approximate amount of money that would have been earned is calculated and then awarded. Medical expenses cover any services, treatment, or medical appliances or the unpaid service of relative or friends. Only such expenses as are considered reasonable by the court are recoverable. So in Cunningham v. Harrison, the claimant said that he needed a housekeeper and 2 nurses to live in his home and look after him. However, the courts refused to allow this claim as it was considered an unreasonably large request. Conversely, Donnelly v. Joyce shows a successful claim in claiming the financial loss that his mother has suffered as a result of her having to take care of him. So, expenses to cover special facilities can cover the cost of a special living accommodation. This is special damages. The measure of damages here is the sum spent to obtain the special facility and its running costs. So, for example, Povey v. Rydal School resulted in the claimant receiving an award to cover the cost of a special hydraulic lift to take a wheelchair in and out of a car. A large amount of money can be spent to adapt a house for people with particular disabilities. General damages refer to all losses that are incapable of exact quantification. General damages are further divided to pecuniary and non-pecuniary damages. Pecuniary loss is a loss that can be easily calculated in money terms, for example, future loss of earnings. Non-pecuniary loss is loss that is not wholly money-based. Future loss of earnings and the major type of pecuniary damages. The courts calculate this amount using the multiplicand, a sum to represent the claimant's annual net lost earnings, and the multiplier, a figure that represents the number of years for which the claimant was likely to have worked. They are multiplied together to calculate future losses. The multiplier is arbitrary, meaning it can never be precise, and is calculated by looking at prior cases. In the case of a young wage earner, the maximum multiplier uses 18 as it takes into account the possibility of job loss/retirement. The expectation remains that the claimant will invest any money received as a lump sum and then use the income, possibly some of the capital, to cover living expenses during the months/years that they would have been working. This means that by the time of retirement, the whole of the sum, spelling mistake, awarded will be exhausted. Victims of the accidents often receive financial support from several sources in addition to tort damage, such as social security benefits, sick pay, and private insurance. These amounts, however, are deducted from the damages awarded to account for these, known as offsetting. Despite this, the claimant is entitled to an award to cover the cost of future care, such as nursing requirements and physiotherapy. Non-pecuniary damages cover damages awarded to claimants where the type of damage is subjective as to the need of the damage awarded. So, that should realistically say sustain, but it gets the same message across. For example, the pain and suffering, compensation for this is subjective, as pain and suffering are impossible to measure in a quantifiable sense. Despite this, it is important to maintain consistency between the award made to different claimants who suffer from pain and suffering and other similar injuries. However, awards can be made to cover nervous shock and physical pain and suffering. The Judicial College sets tariffs to govern the fixing of appropriate figure. However, each tariff provides for a range of possible awards. A claimant who can show that the injury has had a particular impact upon his or her life may be able to recover at the high end of the range. So, a loss of amenity. The claimant is entitled to claim damages if his or her injury led to the inability to carry out everyday activities and the enjoyments of life. For example, the inability to run or walk, play sports, or pursue hobbies such as playing an instrument. An impairment of these senses also count as a loss of amenity. These rewards are assessed objectively, so they are independent of the victim's knowledge. Shepherd, 1964, tackled a 41-year-old woman who suffered a severe head injury. Despite her inability to talk, her eye movement suggested that she understood her predicament. She received a high reward for her loss of amenity. Damages for the injury itself. Injuries are itemized and specific sums are awarded for these based on the precedents. Provisional damages are able to be awarded under the basis that a serious deterioration of the claimant's health or circumstances occurs after a closed case. In ordinary circumstances, this would leave the claimant with no aid to resolve these, which can cause obvious hardship in personal injury cases, for instance. Section 32A of the Supreme Court Act 1981 states that the court is able to provide provisional damages where there is a serious deterioration of the condition of the claimant because of the tort prospectively, so after the fact. This allows the claimant to return to the court should further anticipated serious deterioration occur. This power is uncommonly used, however. In some cases, the defendant will agree to make an interim payment to the claimant. So, mitigation of loss this time. The claimant is required to take reasonable steps to instill a mitigation of loss. The defendant will not be liable to compensate the claimant for any losses that could have been prevented by taking such steps. He or she is under a duty to keep the loss to a reasonable level. This is called mitigation of loss. For instance, the claimant cannot claim for private treatment for the injury if the same treatment is available to be provided under the NHS. The same principles apply to property damage. Irreparably damaged property can result in a claim. Replacing such with a more expensive item would not be allowed. After damages, the most common remedy in a tort is an injunction. Generally, this is an order of the court for somebody to cease doing something. A failure to follow the proceeds of an injunction would result in the defendant being found in contempt of court and can be punished with a fine or imprisonment for a maximum of 2 years. The injunction can be ordered during the case, for example, to disclose documents or not to continue in action until a trial has taken place. Commonly, an injunction can be ordered as a final order, known as a perpetual injunction. This can be ordered in a nuisance case to ensure that the person does not disturb their neighbours, such as banning a certain activity or within certain hours. Less commonly used is a mandatory injunction, which a party is ordered to carry out a certain action, such as soundproofing or an extractor fan to remove offending smells.